Hi, guys. Welcome to Parawomenradio. I'm Amy. Today, your favorite psychopath, Sarah Unintentional Boone, is back in court. We're going to go in and we're going to watch her. We're also going to catch up on her new lawyer. They brought some motions today, and we're going to get into the Sarah Boone suitcase murder case today on Parawomenradio. I'm going to roll some credits and I'll be right back. Welcome to Parawomenradio. I'm Amy.
Carefully strumming this old guitar, words rolling out into the fire. Never ask why my heart burned blue. Here in the haze where you inspire me. Here in the darkness I hear my cue. Time to find some solitude. Here where my soul bleeds openly, deep in the heart of sin and you. Here in the blue, I'm falling deep into you. Here in the blue, I'm dancing with you tonight, and it feels fine. Carefully strumming this old guitar again, words rolling out into our fire. If heaven had wings, I would steal them and fly away with you for a while. Here in the essence of gratitude, your dreamy little smile on my lips. I miss my cue, but baby, I had you. Miss my cue, but I had you for that day.
Ooh, I just realized I had the Highly Strange Days intro queued up. This is Parawomenradio, and I'm Amy. We're going to go into the Sarah Boone case. Tamara, you're so welcome. We've had a few people come through and gift some Dragonfly memberships. Today we're coming to you on YouTube, Facebook, and Twitch. Hi, guys. And hi to everybody in the replay crew. And we've had a few people gift memberships. So I think we've had like 25 Dragonfly memberships, which is the membership program over on YouTube, gifted. So yeah, it's pretty cool. So happy that you're one of our Dragonflies now. Good morning, Paranormal. How are you? So I did see that Sarah Boone is back in court. So what I thought we would do is talk a little bit about Sarah's new lawyer, and then I thought we would go into court. Sarah Boone is the Florida woman who unalived her boyfriend by zipping him up into a suitcase and then going upstairs to her bedroom and passing out, which prompted in George Torres, Jorge or George Torres, to not be alive when she woke up in the morning. So let's get into it. We know that Sarah was went through 8 lawyers. None of them were suitable. Some of them had to drop out because they had worked with her in the past, and so there was a conflict of interest, and or they worked with George in the past. And so some of them weren't exactly her fault, but I'd say a good 4 or 5 of them were. And then the judge finally, because her trial is going to court in October, she's been in the county jail for 4 years now, and the judge is like, come hell or high water, we're going to court in October and you'll be representing yourself, my friend. And so then she put up this huge handmade flyer for a lawyer, and it worked. Miss Sarah Boone got herself a lawyer. Be sure to give this live a thumbs up. Helps us dance out into the algorithm, party out there, bring more people back to the party. It's just a free way to help me out, and it's really, really appreciated.
Boone. She, of course, is the defendant in the Suitcase murder trial. She's supposed to be back in court next week for a motion hearing before her trial, which was set for...
And that's today. The motion hearing is for today.
About 30 days from, just over 30 days from now. She's supposed to be going to trial. You remember, she's ripped through several attorneys. 8 attorneys have withdrawn from her case. So she was forced to represent herself. So the last few times she's been in court, she has been arguing her own motions, handwritten motions from jail, and she's been working through the system as best she can. Well, today, things have changed. It appears as though she has hooked another attorney. A motion for a continuance was filed in Florida for Sarah Boone and on behalf of Sarah Boone, saying that defense counsel has been retained. And this person has met with the defendant 4 times at the Orange County Jail. And during these meetings, the defendant has disclosed potential exculpatory evidence. They're setting the table for this to get kicked down the, kick the can down the old street here a little bit longer and continue this case once again. So is she going to actually stand trial? A little over a month from now, we'll have to wait and see if indeed she has retained counsel. One would think a continuance would be necessary. Michael Jaffer is with us. Michael, the judge has had enough of this, and she put out this plea. I need an attorney. You want to be famous? You'll be on court TV. She even made a flyer, and it appears as if someone has answered the call and has met with her and has filed this motion for a continuance, if indeed.
And when I heard that the call had been answered, I said, of course it was. It's Florida. Of course that call was going to be answered.
Another attorney shows up and says, I am representing Sarah Boone. The judge is going to have to push this, correct?
Yeah, I mean, look at Court TV, being so powerful that even attorneys are taking cases that they maybe otherwise would have rejected, right? Very proud of Court TV, but yeah, the judge is going to have to she's going to have to give her way on this. It has all the upsides and none of the downsides. And here's why. It's not like Sarah Boone is sitting on an island sipping Mai Tais, awaiting her trial and just trying to push and delay the ball so she can continue her vacation. She's in custody, right? So it's not like there's any difference. She's either guilty or she's not.
I feel like she is very afraid of going to prison, and so she's just trying to draw this whole thing. Well, she has been drawing this whole thing out. It's been ridiculous.
Guilty. She's already basically serving a sentence of a person who's guilty of this, right? Giving her an attorney, especially when an attorney has showed up for four times and is filing motions, it has all the upsides for the judge. Judge doesn't want to have Sarah Boone defend herself and turn this case into a circus and then, come back on appeal and say, well, I had an attorney. You didn't let me have an attorney. No, the judge wants her to have an attorney and lose the right way, right? And this, by the way, this case is an imminently winnable case. Not winnable in terms of Sarah Boone is going to walk out and get a not guilty, but winnable in terms of it could be dropped down to voluntary manslaughter. I mean, this has voluntary manslaughter written all over.
It's quite possible that this new lawyer will get her a plea deal. And I mean, I don't expect Sarah Boone to go away for the rest of her life, but I think she deserves a good 20 years, 20 years at least. And she's done 4 of them in the county jail now.
Over it, right? So, I mean, an attorney could really do right by Sarah Boone and the system and make even the judge happy. So she should have an attorney. If she doesn't fire this attorney, great. If she fires this attorney, honestly, for some reason, I feel like if the judge allows Sarah Boone to postpone her trial, have her attorney, and then she fires this attorney, I think she's done no matter. I don't care if the Supreme Court justice retires and wants to defend Sarah Boone. At that point, the judge is going to tell her you're done.
Yeah. Michael Jennifer, thank you. We need a break.
At it again. And now she wants the murder case against her completely thrown out. All this comes after a slew of attorneys resigned from her case. And now she's representing herself. So this same woman who's accused of zipping her boyfriend into a suitcase and leaving him there to die is now the one who filed this new motion, arguing her constitutional right to a speedy trial has been violated. So we're bringing in criminal defense attorney Cashapp Early to break down this new motion and look ahead to Sarah Boone's looming trial. Welcome to Sidebar, presented by Law and Crime. I'm Sierra Gillespie. By now, you're probably familiar with the case of Sarah Boone. It's captivated our audiences for more than 4 years now. It takes us back to February 2020, when Boone was hanging out with her boyfriend, 42-year-old Jorge Torres. She says they were drinking and playing hide and seek, as one does, and Torres climbed into a suitcase. Boone says it was all fun and games, but take a listen for yourself.
For everything you've done to me.
Sarah.
For everything you've done to me.
Sarah.
You.
Sarah.
You.
Sarah.
Stupid.
Sarah.
That's my name. Don't wear it up.
Boone says she forgot about Torres and the suitcase and went to sleep. She only woke up hours later when her phone rang, and that's when she says she found Torres, who then was unresponsive.
I didn't mean to leave him there. That's what I'm trying to tell you.
You got up and walked away. How is that not intentionally leaving him there?
Because I'm looking at the hole, knowing that it's there. He'll get out and no come. Because you don't.
And then he doesn't. But you don't go check on him. You say you're up for 30 minutes and he doesn't come up. You don't go down and check on him?
I'm in the bed.
So after all this, Boone is arrested and charged with second-degree murder in Torres's death. She's booked into the Orange County Jail in Florida, and that's where she's been.
Morning, Pauline. It's the daytime, so I've got a loud little bird on my end. So I'm trying to keep my microphone muted, and then I forget. So I apologize if you encounter any spaces where either there's a bird screeching and or I'm talking, but I've got my mic muted.
Ever since. The case has seen some movement, though. She's gone through 9 different attorneys and written hundreds of pages of letters to her case's judge, demanding new counsel or even simply complaining. So all that leads us to where we are right now. Boone is representing herself. Her case is set to go to trial in October, and she wants it thrown out. So now let's break down this new motion and see if it'll hold up. For that, we turn to criminal defense attorney Cashapp Early.
My boyfriend and I were playing last night, and I put him in a case and we were playing. I'm the blue-eyed white dragon.
For the purposes of trial, you will be hands-free and you will not be shackled with legs.
Okay, so I will be unbound. I know this is a lame question, but what does sustain mean?
Sarah Boone could have the help she wanted when she appears today in court with her new attorney. But the suitcase murder trial could be delayed yet again if Boone and her counsel get their way. And from Dancing with the Stars to a domestic abuse charge, the arrest of a dance pro married to a retired
Oh, good. I know that he annoys some people, and that's basically why I've pushed all my lives till the nighttime. But, you know, I miss doing my daytime lives, and things like Sarah Boone pops up. So I'm glad that people are understanding too about him.
WWE wrestler is leaving us with more questions than answers. Also this hour, a woman accused of killing her husband says that her 7-year-old was one of 2 people who really murdered him. We're talking with her defense attorney live. Plus, Donna Adelson's last court appearance gave us an idea of what her upcoming trial could look like. It is all coming up next for you right here on Opening Statements. To Opening Statements, I'm your host, Julie Grant. Police say the man who hit and killed them. We've got jury deliberations resuming this morning in the broken trust abuse trial. One of the juries, guess what? This morning we're seeing that Sarah Boone may have a little help in the courtroom from
So we're going to watch the report on what went down in the courtroom, and then we're going to go into the courtroom and watch what went down.
An attorney from Pensacola, Florida, who is stepping up to represent her. Now, if you remember, she's gone through 8 lawyers previously and was essentially made to represent herself.
For the reasons that the court identified in its 16-page order previously entered, your request for standby counsel is denied.
So Sarah Boone then created an advertisement. Remember this? She advertised for an attorney to help her, and it appears it worked. Because on Friday, attorney James Owens filed his notice of appearance and then immediately filed a motion asking for a continuance. In the motion, he noted that he was drawn to the case after, get this, seeing her advertisement from watching court TV. How about that? Now, in an interview with us, Owens says, quote, "She hired me. She retained me. It's a little different because it wasn't someone who was handed to her. She picked me. I plan on seeing it through, and I'm determined to help her see it through." End quote. All right, we'll see what happens this morning. Let's talk about this. I've got 2 great guests standing by. The Director of Prosecution Projects at Florida International University.
Do you think she's going to fire this one? I don't think she is, because I think she has come to understand how important it is that she have an attorney. So I think she's going to stick it out with this one.
She's a former homicide prosecutor. Melba Pearson is with us. And want to welcome back in forensic psychologist, expert witness, Dr. Michael Brannon. Great to see you both. Oh boy. Okay, so the likelihood, let's just assume that everything works smoothly. He shows up at court this morning. The judge notes that he is now a counsel of record. Will he be given a continuance? Melba, what do you think?
Yeah, good morning, Julie and Doctor. I think that he's going to get that continuance. It would be an appealable issue, I think, if he doesn't, because he's brand new, just stepping into the case. He has to have the opportunity to read the file, prepare. If he was just retrained on Friday or basically in the last couple of days, there's no way he can get up to speed to effectively try this case. So I think a short continuance will be given to him. Now, I don't think it'll be 3 months or something like that, but I could see a scenario of a couple of weeks to a month in terms of a reset date in order for this trial to finally move forward.
Sure. Appreciate it, Melba. I have a little bit of the motion for continuance we extracted just to see a little bit of what he says. And get this, he talks about meeting with Sarah Boone 4 times at the Orange County Jail already. And he says during the meetings, they discussed exculpatory evidence on her phone, which they hope will potentially corroborate her battered spouse syndrome defense. Dr. Michael Brannon, this is where I want to bring you in. We all saw you testify in Marsha Thompson's case, and you were really the star of that trial, the breakout star of that trial. Your expertise really shined. Looking at this case, and I know you haven't personally evaluated Sarah Boone, but based on what you know and the facts we see them, do you think she could be successful on a battered spouse syndrome defense?
Well, good morning, Julie, and Melba, too. Good morning. So it's a very difficult defense, even when everything is all put together nicely for the defense to occur. And there has to be a number of different elements that fit in order for the battered spouse defense to be successful. And in this particular case, I
think it's a particularly bad defense for Sarah Boone, because in order for that defense to work, you have to be likable. And I don't think Sarah Boone is likable. I think the opposite is true, that she's the unlikable one and the victim is the likable one.
No, there's a reason why people go through a lot of different attorneys. Some of them may just be stall tactics. Some may be trying to establish a certain defense. But attorneys may be, and again, I didn't talk with her. I don't know that much about the case. But attorneys may have already told her, listen, you don't meet the elements of this, or this is not going to be successful, trying to give her the benefit of their legal knowledge and background. And she may not have been willing to accept that. She may have heard from other inmates or family members, or she may have seen court TV and thinks it may be a good idea, but the facts of that, the elements may not apply directly to her case.
Appreciate that, Dr. Brandon. We know in one of the motions that her new attorney filed, he said that he's looking for additional discovery. And of course, that caught our attention because we're thinking, what else is there? We've been talking about this case for years. Melba, as you know, you've given us analysis for years on this one. What else could possibly be there? It seems like Sarah Boone is hung up on discovery, quote unquote. We've seen her, there before the judge saying, I'm not being given everything. I'm not being given everything. And, looking as a spectator, someone who's on the outside, I'm not part of the case. I'm not the prosecutor. I'm not a defense attorney. I'm just scratching my head because we know there were two people at that house that night, the two of them, when this happened, and she created the most incriminating evidence by filming him and not letting him out of the suitcase. Melba, do you think this motion could have teeth? Do you think this is a formality? I'm curious your legal opinion on why this attorney would say he thinks there's still something outstanding that hasn't been turned over by the state.
So, of course, as in any prosecution, you have the duty to turn over any evidence that you're going to be relying on in trial, or just generally, and my always rule of thumb was always, when in doubt, send it out, right? So that way there's never an issue later on down the line. You didn't turn this over. This could have been exculpatory. You mentioned this in trial. I didn't have access to it before, et cetera, et cetera. So sometimes in homicide cases, when you have a lot of different witnesses, you have many different people that authored reports. You may not, there could be a situation maybe where one or two reports didn't get turned over. It happens. It's often accidental. Not anything untoward, but it happens. So it's possible that the defense attorney, in the abundance of caution, is just renewing his request for any and all discovery that might be pending, just prompting the prosecutor to go through the file again and just ensure there wasn't anything turned over. Now, of course, it could be a stall tactic on the side of the defendant, because again, yes, to your point, Julia, she knows what discovery she created, but also it's a tactic to know, is there anything else out there that can be used against me? And how do I deal with that? How do I handle that in advance of the trial?
Excellent insight from you as always, Melba. Thank you. Dr. Brandon, let me go back to you, please, on the issue of battered spouse syndrome. Sarah Boone, we know, is a very strong-willed, shall we say, woman who seems to know what she wants. She had difficulty getting along with the 8 prior attorneys. Maybe 9 will be lucky number 9, who knows? But tell me, if she is intent on going forward with this defense, or at least exploring it, what does that look like from your perspective in consulting? Would you kind of take us behind the scenes? How would that go?
Sure. So you'd want to know right away whether there's any control tactics that were being done by the victim in this case. Was there a pattern of abuse? Was it ongoing? And was the individual, the victim in this case, so controlling that she wasn't allowed to contact, be in touch with other individuals, be in touch with family members to try to get help? And did she make other attempts to try to get away from the abuse? And I'd also note that the method of death here that was utilized by Ms. Boone on the victim, it would be unusual for a battered spouse case. Usually the actions are impulsive, they're quick, a quick gunshot or a quick stab wound. But this type of killing is really unusual and almost unheard of for battered spouse cases. So they'd have to overcome that as well, because it appears that there's some thought, some intent, but also some lingering time for her to think about what she's done. And oftentimes those are not synonymous with battered spouse offenses.
Appreciate it, Dr. Brandon. So in terms of what we may see today, Melba, as we go into the courtroom, what are you expecting from the judge? Are you expecting the judge to willingly accept this attorney's involvement in the case now?
I mean, he doesn't really have a choice. It's one of those situations where this is who the defendant has selected to represent her. And so the judge has to give him the same equal treatment he would give to any of the other attorneys, whether it be the first one or the 8th one that showed up in court. So he has to listen to the defense counsel's argument as to why he needs a continuance, how long he thinks he would need, what he's seeking, or if he knows what specific piece of evidence is missing or what piece of discovery hasn't been turned over later.
Honestly, I think the judge is probably pretty happy that she found herself a lawyer, because it would have been a long, painful process if she didn't have a lawyer.
That out. So the judge is going to have to listen to all the arguments and make a decision as to if he's going to get a reset or a continuance, and if so, for how long.
Appreciate it, Melba. Dr. Brandon, tell us, what are you looking for as this progresses? What are you listening for, watching for with Sarah Boone's trial?
So does the evidence show a pattern of abuse? And does the evidence show that she's tried other methods to try to escape from that abuse? And remember, these are difficult defenses. And the reason why they're difficult is you're asking jurors to not believe what they see, but to really believe what they can't see, which is what a person's thinking and feeling. And the attorneys in this case, with their evidence, have to be able to show what she was thinking and what she told other people. And not just what she did, but what she didn't do. All those things are very, very important in establishing a battered spouse syndrome case. In this particular case, if she hasn't shown those elements, it'll be difficult to get that forward with a jury.
Appreciate it. Excellent insight from you both. Dr. Michael Brandon, thank you kindly. I know we need to let you go and get on with your day. Always a pleasure to have you on opening statements. Thank you. And Melba Pearson's going to be staying with us as we continue the show. We hope you do the same. As we come back from this break, we're going to talk about how a Napa Valley arrest has put the focus on one high-profile celebrity couple. What do the charges in this case tell us? That is what's trending in true crime. Plus, Donna Adelson back in the Florida courtroom last week as her trial is quickly approaching. We'll talk about...
My name is Artem Chigmintsev, and I've been on Dancing with the Stars for 8 seasons.
Sorry, I just want to see this really quick. Is this the same? Is this one of the same? Was she a twin? Does she have a twin?
I'm actually very happy that I got Artem. I body slammed him and he survived. That means he can handle me.
It is.
Oh, very talented couple they are. Many of us know Nikki Bella Garcia and Artem Chigmintsev. We know them from the WWE and from Dancing with the Stars. Now, one of them has been arrested on domestic violence charges. Chigmintsev was booked in the Napa County Jail last week.
Okay, let's move on and let's go into the courtroom. Pauline said, if she hadn't made that recording, I would have bet she would have only been charged with, yeah. And if she would just get it over with, but, you know, she's been in that jail for so long and she's probably, you know, as horrible and heinous as she is, she's probably the big cat on the totem pole right now, and she doesn't want to lose that and have to go into court or into prison. But I would just do it and get it over with. Okay, so we're going into the courtroom. The audio hasn't started yet. I do plan on going to this trial and covering it live once it's happening, once it begins. It'll be my first one that I do something like this, and I'm pretty excited about it. And I want to eventually travel around. Like, I would have liked to have gone. I know it's been, I don't know if it's going to ever happen, but that Alexi Trivicio case, the girl who put her baby in the bathroom, that case I would have liked to go to. I would still like to go to the Lori Vallow, the Arizona trial. Those are just off the top of my head. And I know the Alexi or whatever, Treviso, that one's not happening. It got thrown out, but I still think they might.
Oh.
Okay, here we go.
Sir, hang on 1 second. I'm waiting for the state. Thank you for your patience.
Be sure to give this live a thumbs up for me, you guys. Helps me dance out into the algorithm. Party out there, bring more people back. And if you really like my channel and you're not subscribed, please subscribe. Oh, it's the first of the month, so I'm going to be able to start gifting some memberships. I wonder, are you a dragonfly, Pauline? I think you are. Let me see if I can gift you one. It might let me because it's the first of the month. Let me see if I can gift you something. It'll probably, sometimes it'll gift people, but it won't gift the people that are in the room. So hopefully it'll do it for you. Let me see if it works. I don't think it's getting you. It didn't. See, it gifted 5 other people. I'm sorry. I tried. It gifted Jakarta, Wing Beats, Joy, Tammy, and Noodles. Oh, you were planning on going yourself? Oh, which one do you want to go to? Because maybe we could meet up, Pauline. Or even both of them. Because yeah. Okay, so I wasn't looking at the screen. Let me see. This is the new lawyer. It's probably good that it's a man. I think she will take she takes direction better from men than she does women, I suspect. Let me while this is going, let me see if I can see if there's any updates on the after the hearing so that we can watch something afterwards. Nothing yet. All right, I'm going to move it forward so that we start it. I thought hold on a second. All right. There she is. Oh my gosh, she thinks she's something. Look at her. Ugh. Ugh. Well, no. Everybody deserves to think that there's something every so often. Yes, I'm planning on going to Sarah trial and then take a cruise out of Florida. We should definitely, yes, for sure. Let's meet up. But it's probably going to happen next year now. Or I don't know if they can move it to November or December. I suspect it's going to happen in January, which would be really nice because, in my opinion, it's really nice in Florida in January. It's not too hot and it's not too cold. Oh my gosh. Okay, here it goes. We're going to swing it over to Sarah. Oh my gosh, where do I sit? Oh, hi. Oh, there's my lawyer. She must think he's handsome too. Look at her. She's even blushing. Look at her. Oh, gosh, it's uncomfortable to see her like that. Knowing what we know about Sarah. She doesn't look as put together as she normally does she? Unless she's trying to look a little different. Like, I don't know. She looks different. Am I wrong? Does she look a little like her hair's a little more windswept or something? And she's never done that before where she giggled while the camera was on her. She's never done that. I've never seen that, I don't think. Who, me?
Judge,
Yes.
I'm James Owens, and
I used the big words.
Sir, good morning, pleasure. Ms. Boone, good morning. Could you please state your, raise your right hand now, first, and go ahead and swear you in.
Do you solemnly swear or affirm that the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth?
Yes.
Ma'am, good morning. Could you state your full name and date of birth for the record for me?
Sarah Boone, 10-10-77.
Good morning, everyone.
Oh, 10-10. She's about to have a baby, a birthday.
The first is the court's notice of hearing that was sent out last week. The first issue on that was addressing the viewing of the physical evidence here in open court on August 5.
I thought they were going to unhandcuff her and that kind of stuff so that she could write. I do remember that.
Deadlines and scheduling, including the viewing of the digital evidence no later than September 3, and the physical evidence viewing to take place here in open court on September the 3rd, and a schedule for objections thereafter. The digital evidence review took place on August 9th, and the August 23rd deadline for objections.
So I'm gonna stopping it and starting it, and just come right down into the comments and let it run. And watch it with you guys, okay?
Has since passed. On August 14th, the court was advised of an alternative arrangement and advised the state to file a notice reflecting when and where and how that review would have taken place. I did not receive or see such a notice in the court file. Mr. Cashapp.
Yes, Your Honor. We were not able to file the notice prior to today. However, on Friday, August the 30th, we were able to have that evidence review of the physical items with Ms. Boone at the Orange County Jail.
Okay, all right. Ms. Boone, can you confirm if in fact that viewing took place?
It took place.
Okay, all right, very good. And who did it take place between the state, yourself, and was Mr. Lane with Prison Break Investigations a part of that viewing?
Correct.
Okay, all right, thank you very much. Also set for hearing this morning was defendant's motion for payment of costs and appointing neuropsychologists to assist the defendant in preparation of the defense that was filed on August 14th. The next day, August 15th, JSCS filed a response to the motions for payment of costs and appointment of a neuropsychiatrist. Paragraph 10 of the JSC's response reflects that the JSC will not be participating in this hearing. Mr. Owens, good morning. What is your position, sir, with regard to Ms. Boone's pro se motion for costs? Are you adopting that motion?
I'd like to abandon that one, but substitute it in for two other motions for the appointment of a forensic psychologist, Dr. Julie Harper, who was on this case previously. I believe she saw Sarah Boone about 6 times at the Orange County Jail. She was working under the direction of the original counsel, Mr. Padilla, who I believe had the case for about 2.5 years. And I think it was set for trial, ready to go, and then at the last minute he withdrew. I tried to call him a couple of times, haven't been able to find out what went on. I have talked to Ms. Cashman, the last lawyer, but we don't need this neuropsychologist that Ms. Boone had requested, but we do need a reappointment of the forensic psychologist, Dr. Julie Harper. I've spoken with her a couple of times last week. I text messaged her 4 or 5 times this weekend. She is in agreement to handle the case, to reopen her file. She has sent me her records. I have reviewed them. I've met with my client. I think my client meets the criteria for that spouse. I believe Dr. Harper, after she gets a chance to re-engage with my client, spend some time with my client, and hopes that she's going to be of that opinion. In addition, I believe it's necessary for the appointment of a crime scene reconstructionist and death investigator, Dr. Michael Berkland, who is from my area, Pensacola, is who I am recommending to be appointed.
What was his name again, sir? I'm sorry.
Michael Berkland. I filed these judges yesterday or last night. I don't know if they're in the court file yet.
I did not see them this morning. I did see the motion to dismiss.
Can I put them in?
Yes. State, have you seen them?
I just saw them briefly this morning prior to the
morning, sir.
Prior to the hearing.
Thank you. The only thing I saw in the court file, counsel, when I was prepping last night was the motion for statement of particulars, the column September 2. I have not yet seen these motions.
Judge, I also filed a motion for additional discovery. I don't know if that made it through as well.
Was that also filed yesterday, sir, sometime in the evening?
It was filed at 8:30 yesterday morning.
So I have your motion for statement of particulars filed at 8:10 yesterday, but I do not have the motion for additional discovery filed 8:34.
I don't know why the court was not able to post that, because they were filed one right after the other.
One's in the court file, the other three aren't. They were all filed yesterday, 19.
No, certain things auto-populate and certain things have to be accepted.
Okay.
The statement of particulars and the additional discovery were filed yesterday morning. The motion to appoint the crime scene reconstructionist and death investigator and the motion to appoint the forensic psychologist was filed at 6:10 p.m.
I do see that. As the court previously identified, JCS chose not to participate in this morning's hearing by virtue of their response filed on August 15th. They are not here. Your motions for these various experts report that they were sent to all persons on service lists through the e-portal. But I don't know how I can address these this morning without having JCS here. So I will endeavor to coordinate a hearing for these as soon as practical. I understand these need to be addressed. Be advised, this is a trial week for the court, as is next week, but I will do my best to endeavor to try to get these heard as soon as possible.
Judge, and I filed my notice of appearance on Friday,
Yes,
and I've spoken with Dr. Berkland 2 or 3 times this weekend. The state was able to provide me with some discovery. I think once I filed my notice early Friday morning, I think the state provided a lot of discovery to me. I provided that to Dr. Berkland. I believe he has the autopsy. We cannot find the autopsy photographs, which he says are critical. We cannot find the crime scene photographs, which he says are critical to his evaluation. So I know time is of the essence. We've got people working on it, but there is some additional evidence that we need.
State, what's the status of the provision of the autopsy photographs and the crime scene photographs and provided to counsel?
We provided all of those things previously, obviously, to the defendant, which has been greatly discussed already. When Mr. Owens' notice of appearance came on the case, I instructed my assistant to go ahead and send copies of the document discovered, which is easily available to him, just so that he could quickly have that and not have to worry about getting that from his client or whatever. I believe we also sent notice to as well that if he wants additional copies of the autopsy and crime scene photos or any other pieces of digital evidence in the case, that he just needs to provide USB and he can go ahead and burn that for him. Again, this is in addition to what's already been provided to the defendant in this case.
Okay, do we have a time frame where we might be able to get that information to him?
If he wants to come back to my office, we can do it this morning / this afternoon.
Is your office in the building?
Yes, it's in the courthouse.
Right there. Come out front door, make a left.
Okay. I don't have a USB with me, but I'll find one. This morning, we'll get that done.
Okay, I appreciate you both. With regard to the motion for additional discovery filed yesterday, September 2, 8:34 a.m., state of you the opportunity to review this.
I just reviewed it just now here in court this morning. The state was going to request an opportunity to respond to both this motion and also the motion to the statement of particulars formally and writing, given the lack of time we had to prepare to make a good formal response.
Sure. And how much time, Counselor, would you like in order to file a response to the motion for statement of particulars and the motion for additional discovery?
I would ask for at least a week.
Any objection?
No objection.
Okay, all right. The state shall file a response to both the motion for statement of particulars and motion for additional discovery no later than the close of business 5 p.m. on Tuesday, September the 10th. And if hearings are necessary, we'll coordinate those. With regard to the defendant's pro se motion for payment of costs and appointing neuropsychologists to assist the defendant in preparation of the defense, the court's going to deny that as moot. And motion to appoint forensic psychologist. State, are you intending on filing a response to these?
No, we're going to take no position on those points.
Okay, all right. I will have Ms. Barrios, I'll ask the clerk to see if we can push these through the portal today so that Ms. Barrios can reach out to JICS and see if we can get a time frame on when they may be able to provide a position statement or a response to those motions, and then we'll coordinate a hearing respectfully.
Judge, I'm going to want to add one other forensic psychologist, make a request. I want to make sure that there's not an issue about my client Sarah Boone and I manufacturing the defense. And there's a second doctor, Dr. Michael Brandon. I don't spell that right for me, sir. Dr. Michael Brandon.
B-R-A-N-N-E-N?
He spells it B-R-A-N-N-O-N. He was the forensic psychologist in the Marsha Thompson case. That was the Palm Beach County first degree murder where she shot and killed her husband. Shot him 9 times. He was laying on the couch and was acquitted of first degree murder back in July of this year. That was a 2019 case, so that took a while to get to trial. But Dr. Brandon testified that a battered woman's experiences affect her perception of imminent danger. And that's going to be a question in this case, whether or not Sarah Boone, at the time of her actions, was facing imminent danger. In addition, Dr. Brandon said victims of repeat violence may fear death in situations others would not.
And
I've tried to reach out to Mr. Brandon this weekend unsuccessfully, and my intent is to reach out to him. I'm hoping he's going to respond. He claims on his website that he responds within 48 hours. That's the only other witness I'm going to need at a point for a forensic psychologist. So 2 forensic psychologists, Dr. Julie Harper, Dr. Michael Brandon, and then the crime scene reconstructionist, Dr. Michael Burke. And then in addition, I would like Billy Lane, who's seated in the audience. He is the investigator on the case. Because of the claims that we're making that she's a battered woman, we need evidence to corroborate that. So there's a lot of history between her and Mr. Torres involving the apartment complex, which is in Winter Park. That was 4 years ago. The ownership of that apartment complex has changed hands, so it's going to be somewhat problematic trying to get information about who all the tenants were that may have witnessed some of the violence involved in these two, as well as we're trying to get together the 911 calls that Sarah made and others have made about the disturbances between that couple. So he's got a lot of work to do as it relates to running down witnesses. In addition, we're trying to get arrest reports of the prior domestic violence arrest of Mr. Torres, as well as the officers involved in their body cams to see if there's any evidence on the body cams that would show injuries to Ms. Boone. So we've got a lot of work to do, but I believe it's necessary for us to prove a viable defense of battered spouse syndrome, that we have cooperation. It's going to take a little bit, but I do need the appointment of that expert. He tells me he's already on. I'm going to have to file something else because it was under Sarah Boone. Now, as the attorney of record, I'm going to have to file something. He says he's still got plenty of hours to work under that original cap. So I'll be filing something today or tomorrow as it relates to that. But that's the only other, of course, I've been retained, so I'm not going to make any claims for attorney's fees. I'm not making any claims for travel costs, just for these witnesses.
The JCS has already approved, I believe, $10,000 in investigation fees and $1,000 for other costs associated with Mr. Lane. That was at one of our previous hearings. Now, that was when Ms. Boone was representing herself pro se. I can't imagine JCS may change their position with regard to those costs, since they've already said yes, but file it and we'll try to tee it up for hearing as well to see if they have any position, or it could just be, the order can be modified to extend to you as counsel for Ms. Boone.
Thank you.
All right. That takes us now then to your motion for continuance file that was filed on August 30th. Courts had the opportunity to review that motion. Any other arguments or statements with regard to that motion? Mr. Evans.
Judge, I reviewed the state case law relating to continuances and the abuse, palpable abuse of discretion when the court does not grant it, but it is critical to my theory, our theory of defense, battered spouse syndrome. And as you know, that takes time to develop, especially when the motion basically speaks for itself, but we're in a time crunch. Essentially, the trial is set for October the 7th. I have to provide a notice of intent to rely on battered spouse syndrome 30 days prior, which is September 7th, which falls on a Saturday, so I believe that gives me till the next business day, Monday, September 9th. But still, 6 days for Dr. Julie Harper to come back out and visit with Ms. Boone, coupled with this other potential forensic psychologist, Dr. Michael Brandon. He's not going to have time to do that. They've got to establish a rapport with her before they can run the testing, spend the time with her. And it involves some extensive history. Obviously, that couple was together for 3 or 4 years. I still haven't peeled back all the layers. I've tried to go through it, but as you know, something like that is going to involve several instances of domestic violence that did not involve law enforcement. That was just between the two. So we've been going through that. We're trying to get some medical records where she was stabbed by Mr. Torres in the leg, and some other evidence. It's just going to take some time, coupled with the fact that I've got to get Mr. Lane to get all this other objective evidence, witnesses, and 911 calls, and arrest reports, and provide that to the 2 forensic psychologists for them to help formulate their opinion as to whether she is, in fact, a battered spouse. In good faith, I believe she qualifies based on my spending 3.5 hours with her Labor Day, yesterday, as well as the other 4 times that I've met with her. I have not spoken to Mr. Cordelia, but I believe that was probably going to be where he was going to go. I was not, involved. I don't believe you were involved at that time. I may have been.
Not me.
Okay.
My predecessor was.
But I think it was always ready to go. And for whatever reason, he withdrew the last moment. And then here we are. But I think it's prejudicial if we're not allowed to present the defense that we believe we have a viable claim, and I respectfully ask. I'm not asking for, I think most times you come on a homicide case, you would need at least 6 months. I'm asking for 1 trial cycle, 2 trial cycles, sometime at the end of the year or first of next year. I can be ready. I think that will give enough time for our experts to visit with Ms. Boone and formulate their opinions. I'm sure the state's going to want to take a deposition. I think they may have the right to hire their own forensic expert to go out and interview to see if they agree. But that's just going to take a little bit of time, Judge. I'm thinking 2 or 3 months, and we'll be ready to go. I'm not asking for a long continuance. The good thing about it is Mr. Cordelia has done a lot of work. My understanding he's taken just about all the depositions. I believe they've been transcribed. I haven't gone through all the discovery. She's got the 2 banker's boxes. She has not gone through all the discovery. We tried, but we have not made it. My understanding is a lot of the 2-hour interrogation with the Sheriff's Department has been transcribed. I haven't reviewed that, but we do have a problem with that interrogation. Now, that's why I made the request about the policy. Our policy in my county, Santa Rosa County, is a little bit different. Based on my discussions with her, we feel like I'm going to need to file some motions relating to that. So, because of that, but ultimately because, yes, could I be ready for trial on October 7th? I believe I could. but not without battered spouse defense, because I don't believe my experts would be ready. And so that's instrumental in our defense.
State, do you have any position?
I guess the state would just respond to a few things. Part of this battered spouse defense has been previously investigated with several Ms. Boone's previous attorneys, and in fact, the state did retain an expert, Dr. Tanya Warner, who's on the state's witness in this case, in anticipation of a potential rebuttal of an attempted battered spouse defense. The state's position would be that we would oppose a continuance at this time. However, the state's not opposed to setting another status hearing sometime next week, possibly, where we could address this and to see if there has been any movement, anything that would either change the state's position or potentially the court's position as well.
I don't think the state's thinking it through, Judge, because if we wait a week, I've got to file a notice of intent to rely on the battered spouse on Monday. We can't wait a week that the time is expired if the judge doesn't continue it today. He wants to have a conference next week, but it's too late for him.
What's your response to the rule requiring these battered spouse or battered wife syndrome defense 30 days prior to trial?
You have to give it.
Right, but I mean, clearly when that rule was created, it contemplated that there would be sufficient time to prepare for that defense within 30 days of trial, which is why they gave 30 days, which is why the Florida Supreme Court said that 30 days, not 60, not 90, not 120.
But in good faith, you can't file a notice of intent to rely on the defense of battered spouse syndrome if you don't have a supporting psychiatrist, forensic psychiatrist, that makes that claim. I just can't say, hey, we're going to rely on it, and I'm putting you on notice. I've got to have some kind of authority. I'm not an expert. I think she needs the criteria, but I'm not a psychiatrist. I'm not a psychologist. I can't make that opinion. I've got to have an opinion from an expert before I can file that in good faith. I can't do it without Dr. Harper. She needs more time. Dr. Brand needs more time.
All right, thank you. State anything else?
No.
All right, thank you very much. All right, Mr. Oates, it seems like you've already started diving into the case and what the court file has reflected. So clearly you've reviewed what is in the court file and the history of this case.
Yes.
I'm sure you've read the court's June 28th order, which was extensive as to the history of this case, multiple lawyers that Ms. Boone has gone through, the reasons for the non-conflicted out lawyers' basis for withdrawal, and why the court ultimately made a decision that Ms. Boone had forfeited her right to court-appointed counsel by her actions, or alternatively waived her right to court-appointed counsel by virtue of her actions. This case has been pending for some time. You advised in your motion to continue that you met with Ms. Boone on 4 different occasions, that you just met with her yesterday for 2.5 hours. You were aware of what the order identified, which was in paragraph 6 of the order in the judge portion, that trial specially set for October 7th, 2024, and that it would not continue for any reason, absent extraordinarily good cause, and such extraordinarily good cause would not include the retention of counsel. You haven't been appointed in this case. When you undertook this assignment knowing that you were not being appointed, and that by your own representation, you're doing this free of charge on a pro bono basis and not seeking recompensation for any lodging or travel. You knew what the deadlines were for the court. With regard to any of the experts, there have been multiple prior experts in this case. You already identified Dr. Julie Harper, a forensic psychologist. You advised that she's met with the defendant on 6 different occasions. She was appointed back on August 3 of 2020. Under Mr. Padilla's representation of Ms. Boone, at no point in time did Mr. Padilla file a Category A witness list disclosing Ms. Dr. Harper as a testifying expert, and as you astutely pointed out, this matter was days, if not weeks, away from being tried when Mr. Padilla moved to withdraw based on the reasons outlined in the court's June 28th order. Thereafter, Dr. Charles Heller, another forensic psychologist, was appointed on February 3rd, 2022, and again on March 1, 2022. No Category A witness list was ever disclosed with regard to Mr. Heller. Then Winston Hobson had an undisclosed expert that had met with Ms. Boone, as addressed in open court on February 9, 2024. And as Mr. Hobson put it, That expert was not meeting with what Ms. Boone had desired or requested of that expert. There was another expert psychologist that was appointed by Patricia Cashman on February 28, 2024, who had expertise in battered spouse and or battered wife syndrome. There were also Dr. Linda Dore, 2 times sought to be appointed, once by Attorney Bankowitz. Dr. Dore specializes in battered wife or battered spouse syndrome. Once by Dr. Bankowitz Mr. Bankowitz, on July 17, 2023, again by Attorney Hobson on January 1, 2024. Based on the 4 Supreme Court decisions in Middleton versus State, 220 Southern 3rd 1152 and 1176, Barlow v. State 221 Southern 3rd 562 at 569, there's a 2-part test determining the need of experts. We're not going to be addressing that today, as you sought to file these other motions that I haven't had really the opportunity to address. And JCS is not here to have the opportunity to review those. In Ramos versus State, 75 Southern 3rd, 1277, and pinpoint 1281, by the Florida 4th DCA 2011, citing to Lawson v. State, 884 Southern 2nd, 540, also by the Florida 4th DCA in 2004. In that case, defendant Ramos changed his defense counsel at least 4 times while this case was pending, with the latest change in counsel occurring 2 to 3 months before the actual trial date. There's no record evidence showing that any of Ramos's previous attorneys had provided ineffective assistance, and the defense had already moved for 4 continuances to prepare for trial. Similar to the Ramos case, Ms. Boone has played a prominent role in shortening the preparation time for trial, as set forth in the court's June 28th order. This case has already been continued 16 times. As of the date of your filing of your notice of appearance on August 30th, this case has been pending for 4 years, 6 months, and 4 days. On June 7th, this case was specifically set for trial on October 7th, and the June 28th order by the court specifically speaks for itself and evidences how Ms. Boone played a prominent role in shortening the time for preparation for trial when her 8th attorney, Ms. Cashman, withdrew. Ms. Boone reached the point where her right to adequate time for preparation and trial was counterbalanced by the right to the effective administration of justice. As of August 30th, when the notice of appearance was filed, there were 37 days until trial commencing in this matter. Considering the prejudice of the denial, Ms. Boone has already availed herself to 4 different attorneys that were not conflicted out, Padilla, Bankwitz, Hobson, and Cashman, and only has herself to blame for the withdrawal of those 4 attorneys based on the representations in those motions and findings in the court's June 28th order. Discovery has been reviewed with Ms. Boone by prior counsels, as established by counsel's representations in various hearings, and prior counsel's motions for attorney's fees, all of which were filed in the month of August of 2024. Ms. Boone has had discovery in her possession since August 5, 2024. The digital discovery that the state seeks to admit at trial was provided to Ms. Boone on August 9. Although you are not court appointed, sir, the court's done its own research with regard to your expertise. You've been barred since October 15, 1986, with a duly elected public defender of the First Judicial Circuit in the state of Florida from 2009 to 2012. You've tried over 100 cases to verdict throughout your career. You've met with Ms. Boone on 4 occasions, as outlined in your motion, not including the meeting that you had with Ms. Boone yesterday. As to the battered spouse syndrome defense, you still have time to file the appropriate notice in accordance with the rule. And considering all the factors as set forth in terms of the state, 311 Southern 3rd, 185, and pinpoint 189, 42nd DCA 2020, your motion for continuance is denied. This trial is still set for October 7th. We will have pre-trial the 6th to 27th. Pre-trial in this matter, or trial case management will still be set for September 26th at 9 a.m.
Judge, a couple of things. Number one, I have full practice. I've got a docket day this afternoon in Santa Rosa County for Circuit Judge Scott Duncan. I've got 12 clients that are pending. I've got other people covering it, but I do have a full docket. If we set some of these hearings involving my motions, could I be allowed to hear my Zoom?
Any objection?
No, Your Honor.
The only request that I would have, sir, is the rules of general practice require a notice regarding your appearance. If you could just file a motion and provide a form order, I'll sign it and you can appear virtually. There's no reason for you to drive all the way down from Santa Rosa County for all these hearings when we can appear virtually. JACS, I imagine, will be appearing virtually for some of these motions with regard to the experts. So as long as you file a notice in advance, sir, I've got no problems with that.
Judge, in that pre-trial order, it mentioned, I thought, that the state attorney was supposed to meet with the defendant and the defendant's investigator and review all the digital evidence from the order. That's the way I read it. They were supposed to sit there all together and watch every potential video exhibit the state was going to intend to introduce at trial. That has not happened. I think today was the deadline for that. I don't mind extending that because I'm going to need to look at the evidence.
With regard to the digital, the deadline, you are correct, sir. The deadline was today, based on the August 5 order. If it did not happen before then, as I outlined at the beginning, there was a change to that process. A thumb drive was provided in open court to Mr. Lang on August 9. He then provided it to Ms. Boone, a thumb drive of the specific digital evidence that the state is seeking to admit at trial, based on the witness and exhibit list that was filed under seal on August 9. Ms. Boone had the opportunity to review that information at that time.
All right, I'm going to ask for more time for me to review the digital exhibits they intend to introduce. I don't know if they've been redacted. I don't know if they're the originals, but I'm going to need to look at that. And I went to the jail yesterday. I had let them know in advance that I was coming. I believe my secretary had emailed them and said I wanted to bring in my laptop and my phone to view evidence and whatnot. I was not allowed to bring in my laptop and phone yesterday for 3.5 hours. So I didn't get done a lot of the things that I wanted to get done within that period of time. Probably would have stayed there a lot longer if I would have had that capability. So I would ask for some more time to be able to look, for me to look through the digital evidence as to what they're, I assume it's being redacted. I know some of the audio in terms of clients' comments the client made, comments the officers made, some of it is, in my opinion, improper to be presented before the jury. So I'd like some extra time to be able to do that.
State.
I'm not certain, is he asking for a continuance again? What is the extra time that he's seeking?
What is it you're asking for? Extra time to do what?
The way I understand the order, I'm looking at paragraph 4 of the scheduling order and notice of hearings that, Judge, you signed August the 5th. Paragraph 4, the state's digital evidence will be reviewed with the state's investigator, the defendant's investigator, no later than September 3rd, 2024. This evidence viewing can be done in advance of September 3rd deadline. The state shall provide the defendant USB drive with the station. They never viewed it with my client in its entirety. As the order states, they were to do by today. So the state attorney has failed to comply with the court's order. I'm saying I haven't had a chance to view it either. Can we reset that deadline?
On August 9th, Mr. Owens, we had a different hearing. And at that hearing, we addressed the digital discovery review. Mr. Lang was here. There was a USB provided in open court. And the August 9 order and notice of hearing identifies a change to that August 5 order. Specifically in paragraph 4, prison break investigations. By and through investigator Billy Lane shall take possession and custody of the USB jump drive, which contains the state's digital evidence, tendered in open court on August 9, 2024, and shall provide same to Major Malik X. Muhammad at the Orange County Jail today, August 9. Paragraph 6, prison break investigation shall file with the court a notice reflecting that the discovery in the USB jump drive, which contains the state digital evidence, was provided to Major Malik X. Muhammad at the Orange County Jail according to the date and time of the transfer. Such a notice was provided by Mr. Lane had filed in the court file. It was discussed at that August 9 hearing as to the revising of the digital evidence schedule. Paragraph 8 states that on August 14th, 2024, 1:30 p.m. a hearing will be held, courtroom 12A, regarding defendant's review of USB jump drive, which contains the state's digital evidence. The defendant's August 7th letter to the court, provided to the court on August 9, and the media's participation in the physical evidence viewing on September 3, 2024. The pertinent case law is attached. On August 14th, we had a hearing, we discussed that, and we identified that she had the deadline until August 23rd to make any objections. Now, under the original scheduling order, which said this matters, which on August 5, which set the schedule for when there would be deadlines for objections, those would be extended by good cause shown. Are you seeking at this point in time to extend the deadline for a period for objections which has since expired?
Yes.
Okay. State?
No.
Okay. How much time would you like, sir, in order to review the state's digital evidence that it seeks to admit into evidence and tender any objections?
I've got to go buy jump drive. I've got to take it down to his office. He's going to give me that evidence. Obviously, I need to review it for my client. I've got a flight out of here around, I think, 4 o'clock. I don't know if I can get it done by then, but I don't see the necessity of an issue, maybe a week prior to trial, whatever that is, a week prior to that Monday, October the 7th, the week prior.
State?
I'm amenable to setting a status hearing that week.
Here's what we're going to do. We'll address any objections to any of the discovery when we have trial case management on the 26th.
Thank you, Judge.
All right. Anything else, Attorney Jones?
Give me 1 minute.
Sure. State, anything else?
Not this time, there are.
Madam Clerk is going to work dutifully to, it's already done? Excellent. I'll have Ms. Barrios, my judicial assistant, forward these to JCS and see if we can coordinate a hearing. State will have till close of business September 10th to file responses to motion for statement of particulars and motion for additional discovery. Parties have no business before the court. You'll have a fabulous day.
Thank you, Judge.
Thanks, sir.
Can I have a word with Sarah?
Absolutely.
Okay, Sarah was doing a lot with her mouth. I haven't noticed Sarah Boone do all of that with her mouth. I think she has a crush on her new lawyer. What do you guys think? Okay, so I did pick up some of the names while they were talking. He had mentioned that, hold on a second. He noted, the new lawyer noted that the psychologist, and this is just, I just Googled her. I don't know if this is the only psychologist, Dr. Julie Harper, that I found in Florida. It looks like she's a psychologist in Mary Easter, Florida, unless it's a totally different Julie Harper. But he said doctor, and this is Dr. Julie Harper. She explains conditions well. She's trustworthy, friendly staff, low wait times, easy scheduling. She has a 5.0 rating. In searching for other Julie Harpers, these Julie Harpers popped up as well. So I'm not really sure which Julie Harper it is that they're talking about, because this is a Julie Harper as well. Expert, oh, this is probably the right Julie Harper. Expert witness, forensic psychologist, Florida and Georgia. Let me make sure you're seeing the right one. You are. Okay. Florida and Georgia, licensed psychologist at Northwest Florida Psychological Services, PA. First licensed as a psychologist in Washington State in 2002, moved to Florida and took an executive leadership position at Bridgeway Center in 2005, overseeing the psychological testing department, supervised interns, and gained the DJJJ program evaluation contact. She opened Northwest Florida Psychological Services in 2010, a clinical and forensic private practice. She specializes in diagnostic evaluations and forensic evaluations. As a forensic psychologist, she regularly she conducts competency evaluations, sanity at the time of the offense evaluations, and provides expert testimony within Florida. She also mitigates evaluations, provides services as a confidential consultant to attorneys. And she's licensed in Florida and Georgia. She went to University of Denver and Oberlin College. Interesting. 1991 to 1995. She's a Gen Xer. She's endorsed by Kevin Groom and endorsed by 6 colleagues at Bridgeway Center. She's got 22 endorsements. She's endorsed by some attorneys. She's endorsed by quite a few people. Well, I mean, 22 people to be exact. So that is the psychologist that will be handling it. And then I saw that they mentioned the investigator, Billy Lane. And this is Billy Lane. Investigator Billy Lane spent most of his adult career working in law enforcement and wore many badges over the years. Billy has an extensive investigation background, including gang intelligence. Oh, Sarah's going to need that. Computer forensics, undercover narcotics, and human trafficking. Through years of work in local and federal law enforcement, Billy joined these skills, which resulted in hundreds of arrests and indictments over his 20-year career. Billy's most significant accomplishments was his time on, that's too big, on the Homeland Security Investigations Federal Task Force. Billy is still using his investigative skills, but no longer in law enforcement. Billy is now a private investigator licensed to work in Florida, California, Georgia, Louisiana, North Carolina, Tennessee, and Virginia. I wonder how you get your license in all those states. Billy is the owner and chief investigator of Prison Break Investigations, one of Central Florida's largest criminal defense investigative firms. Billy is proud to partner with several retired state officers, federal agents, and former military service members, and together they are available for hire. The investigation scope primarily surrounds missing person cases, but other investigative matters. Didn't Billy have something to do with the Brian Laundrie one? I just feel like he did. don't know if he did. Although it seems like if he did, he would have put it in this. So let's see if there's any more on Billy Lane. Well, he's pro-Trump. This is his Facebook. Oh, he's a little dog lover. Maybelline, he's a little dog lover. She doesn't care. Let's see. Here, so proud of being a part of such an amazing group of professionals. Missing person. Oh, is he doing Native American searches? Native American women. Tampa, Florida. This is a woman that went missing in Tampa, Florida. I don't even know how to say her name. Yancy Vega. There is no greater honor than being bring a family's missing loved one home. Virginia Kennedy Luis looks like he brought somebody. Oh, is this the man that had Alzheimer's dementia or something and he brought him home? Oh, wait. Somebody who had passed away. He found their body and their motorcycle. Okay, so he does that kind of work. Oh, he worked with Dog. Of course he worked with Dog the Bounty Hunter. Oh, is it this? No, this is Billy Lane. Has he been on Dog the Bounty Hunter? Probably. Okay, wait, what's that in here? Left job at Department of Homeland Security. Left job at Lakeland Police Department. Started new job at Prison Break Investigations. Ooh, it's a pretty house. Little cabin in the woods. I want a cabin in the woods. Okay, let's move on. This is the lawyer that took on the case, James Owens. Make sure you're seeing it. You are. Okay, so this is James Owens, attorney at law that took it on. You can text him if you want. Does it say any of his cases? Over 35 years of experience in the courtroom, knowledge of both sides of the law as a former criminal prosecutor. Oh, he was a prosecutor. Virtual consultations and yeah. There's no case too complex. Milton, Florida. I don't know how far is Milton, Florida from Orlando because I know he had Milton, Florida because he took a plane, didn't he? Let's see. Ooh, it's far. It's 6 hours and 6 minutes away. 430 miles. So yeah, he had to take a plane in. And so that's her attorney. It's a service area. He just has the upper part of Florida, so things must be slow for James Owens. There he is. This is the man that Sarah Boone was making goo-goo eyes at today. Well, it was either him or Billy Lane. Do you think it was her new attorney or Billy Lane? I think it was her new attorney because I have never seen Sarah Boone smile like that. Okay, bye, Paula. See you next time. Actually, I am going to be winding this up anyway. I just wanted to put out there the new. Oh no, actually, I want to show this before we go. I want to show my clerk shows that we still have the trial set for October 7th. There's a trial management conference on September 26th. I don't know. Is he doing a hearing on the 24th? It says a Lisa Munyon hearing. Canceled the trial management conference. Oh, they moved the trial management conference from the 24th to the 26th. And then here, per the court, comments case to remain as previously set. Attorney may appear virtually for any hearing that is set. Parties to coordinate hearings for motions. Defense motion to continue. Denied as stated on record. State objected to continuance. So it was denied and everything is set for, I wonder what they're going to come up with next, because I know they've got to have more tricks in their bag. That can't be it, can it? Can it be that easy, that simple, that we're going to go into trial October like that? I don't know. What do you guys think? Put a 1 if you think yes, that the trial is going to happen in October, and put a 2 if you think no, and put a 3 if you just don't know. I'm going to vote 2. I don't think it's going to happen, but I'm the guessing psychic. I'm 50-50. So I could be right and I could be wrong. Who knows? Okay, so happy Tuesday to all my lovelies. I'm going to go. I wanted to share this. If nobody's told you this today, I'm going to tell you this. I love you guys so, so much. And I'll see you next time. Trying to find my closing. There it is. Bye, guys. Hi, guys. Welcome to Parawomenradio. I'm Amy.
Carefully strumming this old guitar, words rolling out into the fire. Never ask why my heart burned blue. Here in the haze where you inspire me. Here in the darkness I hear my cue. Time to find some solitude. Here where my soul bleeds openly. Deep in the heart